Greetings. On behalf of the Office of Human Rights, welcome to the Investigating Abuse and Neglect training. The Abuse and Neglect investigation training for community providers is provided to communicate clear and concise expectations while allowing for each community provider to establish their own unique internal protocol for investigating abuse and neglect. Note, it is the responsibility of you as the provider to develop internal policies and procedures related to the reporting and investigation of abuse and neglect that are aligned with the human rights regulations. Please note that this presentation is meant to be an overview of the investigative process. It is designed to add some sense of familiarity with best practices related to investigating abuse and neglect allegations. You are encouraged to continue building your skills as an investigator by researching other resources. For example, other trainings, reviewing other literature, etc. The majority of the information presented in this training has been adapted from the Labor Relations Alternatives Incorporated Investigations Manual. To effectively perform your duties and your responsibilities as an investigator, it is imperative to have an understanding of what constitutes abuse and neglect. Definitions for anything Office of Human Rights related or human rights processes rather can be found in section 30 of the human rights regulations. That's 12 VAC 35-115-30. The definition of abuse is complex in that two parts must be satisfied in order for abuse to have occurred. So in considering whether abuse occurred, we encourage you to perform what we call a two-pronged test. First, you have to determine whether the act or failure to act by the employee was done so knowingly, recklessly, or intentionally. So what do those three words mean? Let's break those down. Knowingly means that it was done with a sense of consciousness or awareness. Recklessly means that it was done with a sense of carelessness or inattention or a deviation from the provider's internal policies and procedures or the human rights regulations for that matter. Intentionally means something that was done deliberately or willfully. The second test or second part of the two-pronged test is determining whether the act or the failure to act by an employee either caused or may have caused physical or psychological harm, injury, or death. What is important about abuse and the other definitions that we'll cover here in this presentation is that they are not subjective. You have the regulatory definition to aid you as you investigate and prepare your recommendations for findings. Although you may encounter abuse allegations that appear to be similar or the same in nature, for example, you may have multiple excessive force allegations or multiple verbal abuse allegations. What is important is that you investigate each of those allegations as its own allegation. You cannot make generalizations when investigating abuse or neglect. So some examples of abuse are included here on your screen, and they include sexual assault, physical assault, using threatening language, and the improper implementation of a restraint. Also, note that this list of examples is not exhaustive, but it provides some context to understand what types of behaviors constitute abuse. When reporting allegations of abuse in CRIS and then subsequently investigating those allegations, You will do so by designating the type of abuse that was alleged to have occurred. The types of abuse are physical, verbal, sexual, and exploitative or exploitation, and then use of excessive force. Some examples of physical abuse include things such as pushing or shoving, grabbing, pinching, using your hands to control an individual when it's not necessary for their safety. Some examples of verbal abuse include name calling, making fun of an individual, threatening an individual, and also using pet names. So be careful that we're maintaining those professional boundaries at all times. And then lastly, some examples of excessive force include the use of restraints for longer than necessary to ensure that individual safety or the people around. And also putting the individual in restraints without a physician's order. Um, and some other examples of excessive force include using any non-approved holds or physical interventions. Another example and category of abuse that may often be overlooked or not fully realized is exploitation. So be mindful that exploitation is not just relevant or is not just concerning financial misconduct or financial misappropriation on the part of the employee. It also refers to an employee's use as an authority figure to intimidate or bully an individual to get a certain result. Some examples of exploitation include using an individual's belongings without their permission, accepting gifts from an individual, or encouraging an individual to make a purchase with their money for something that you, as the employee, may want. What is important to understand about neglect is that it is a failure to abide by policy and procedure, the treatment or behavioral plan, or a denial of an individual's basic right to dignity that places that individual at risk of being unhealthy or unsafe. Whether neglect occurred may seem somewhat of a sticky situation. However, it is rather simple. Did staff do what was supposed to be done in the manner that it should have been done? Also, what did the provider's internal policies and procedures mandate? So, those are just a couple of questions that you may want to ask yourself in beginning to identify whether or not neglect occurred. Of course, they're not exhaustive or comprehensive, and meaning that those are the only two questions that you need to ask, but they trigger your thinking as you begin to investigate to determine whether or not there's a preponderance of evidence to suggest neglect. And we'll, of course, talk more about preponderance of the evidence as we go further in this presentation. So here on your screen are some examples of neglect. And I'm sure as you all have been working in the field and have seen many things that you are familiar with some of these examples and even more. Again, this is not an exhaustive list, but it just hopefully will trigger you in being able to more easily identify situations that may be the result of potential neglect. When considering whether there was excessive force or improper use of restraint, there must be a clear understanding of what constitutes restraint. Appropriate restraints are those which use a mechanical device, medication, or physical intervention to prevent behavior that places an individual at imminent risk. So let's talk about these three types of restraints. A mechanical restraint is the use of a mechanical device that cannot be removed by the individual to restrict that individual's freedom of movement or functioning of some part of that individual's body. A pharmacological restraint is the use of any medication administered involuntarily for the emergency control of behavior. And lastly, a physical restraint is the use of a physical intervention or hands on hold to prevent an individual from moving any part of that individual's body. It is important to understand that an allegation is not a conclusion of guilt, it is an assertion of possible wrongdoing. Therefore, as is the purpose of this training, an investigation must be conducted to determine whether there is a preponderance of evidence to support the allegation or not. The provider must be diligent in recognizing factors that may appear to be potentially abusive, neglectful, or exploitive, and report to the Office of Human Rights via CRIS within 24 hours of awareness of the allegation. Any person conducting an abuse or neglect investigation must be trained to do so. And evidence of that training must be documented in the personnel record. Additionally, any person who is the subject of an investigation, despite whether or not they are trained to conduct abuse and neglect investigations, that person may not investigate any abuse or neglect allegation that they are the subject of. Though the human rights regulations only stipulate that the results of the investigation be documented in CRIS, providers should maintain an internal investigation file that includes a written report of the investigation. For your information, the Office of Human Rights does conduct look behinds and will ask for this internal file. The regulations stipulate that all investigations should begin as soon as possible. However, investigations must begin no later than the next business day following receipt of the allegation. The director of the program is the custodian of the investigation, meaning they finalize the investigator's recommendations and any applicable action plan. It is the director's responsibility to inform the individual and AR, if applicable, of the final decision and applicable action plan and their right to appeal and the process to appeal the decision or action plan in writing within 10 working days of the results of the investigation being submitted. According to Section 230 of the Human Rights Regulations, allegations of abuse or neglect must be reported in CRIS within 24 hours of receipt of the allegation. And that's specifically in subsection A, 1, and 2. The results of the investigation must be documented in CRIS within 10 working days from the date the investigation began, unless an extension has been granted. And that is in subsection A3. Lastly, all deaths and serious injuries that have the potentiality of abuse or neglect must be reported in CRIS within 24 hours of discovery and by telephone to the authorized representative, if applicable. And that's in 230B, as in boy, 1 through 2. 230B, as in boy, 3, mandates that the provider's report of any of these deaths or serious injury include the date and place of the death or serious injury, the nature of the injuries and any treatment received, and the circumstances surrounding the death or serious injury. The human rights regulations provide for due process for individuals who believe their complaint was not handled according to the regulations. The individual may appeal the director's decision and or action plan to the LHRC, which will conduct a fact-finding hearing. Should the program or the director or individual not agree with the LHRC, either party can appeal to the state Human Rights Committee. The SHRC, though, is only hearing evidence to ensure that LHRC followed appropriate processes. They are not going to hear new evidence. It is important for you as the investigator to understand and to know that you may be called as a witness to discuss your investigation and the relevant facts surrounding the investigation. Depending on your organization structure, the trained investigator may not be responsible for entering data in CRIS. However, it is important for the trained investigator to understand the regulatory requirements and process for reporting in CRIS. So CRIS is DBHDS's web-based reporting system. All allegations of abuse and neglect must be entered in CRIS per regulatory requirements. Specifically in Section 230 of the Human Rights Regulations, each allegation of abuse and neglect must be entered in CRIS within 24 hours of receipt of the allegation. Additionally, the trained investigator must provide a written report or investigative summary to the director with the recommended findings within 10 working days from the date the investigation began, unless an extension has been granted. Now, if you've been paying attention, you know that we just discussed this on the previous slide. It's being repeated again because it is very important that you as the investigator have a clear understanding of regulatory timeframes and regulatory reporting. The assigned advocate will monitor the provider's compliance with the human rights complaint process and reporting requirements via CRIS. In addition to reporting each allegation of abuse and neglect to the Office of Human Rights, the provider must abide by mandated reporting requirements. Therefore, the appropriate Department of Social Services agency should be contacted about all allegations. So in other words, CPS for children and APS for adults 18 years of older, or age 60 and over, and those adults with limited capacity, those lacking capacity. Also, if the allegation is criminal in nature or there is a suspicion of criminality, the provider must notify the appropriate law enforcement authority, whether that be the local police or the state police. And this contact or notification information will also be documented in CRIS. Now it's time for the nuts and bolts. Let's move now to some specifics concerning the investigative process. Again, as stated in the disclaimer, the information presented here is an overview of best practices. The Office of Human Rights is not stipulating that each provider must follow these processes and procedures exactly or to a T. All providers should, though, have internal policies and procedures that address the conducting of abuse and neglect allegation. A concrete protocol ensures as much consistency as possible. Having a framework, in other words, your policy and procedures, decreases some of the subjectivity regarding the process. However, it is important to keep in mind that no two investigations are the same. The Policy and procedure should include, at minimum, elements of an effective investigation. In other words, reporting procedures, detailed investigative processes that include how investigators are assigned. Remember, the internal policy and procedure must be aligned with the human rights regulations. In developing the internal policy and procedure, careful consideration should be given to sections 175 and 230 of the human rights regulations, the complaint process and provider reporting requirements, respectively. What are the specific timeframes and deadlines for your organization? How are investigators informed about allegations of abuse and neglect? And how are investigators assigned? Other than the director and investigator, which other staff will play a part in the investigatory process? You want to make sure the roles, the duties, and the responsibilities are clearly defined. Ensure that you have a process and a procedure in place for when or if your primary investigator may be the subject of the allegation or the investigation. Remember, per section 175 of the Human Rights Regulations, specifically subsection F4, the investigator cannot be involved in the issues under investigation. Lastly, what is the timeline of the investigative process, which of course must be tied to the regulatory reporting mandates? For the purpose of investigating allegations of abuse and neglect, investigations cannot be superficial. The investigation has to be a systematic process of collecting the facts. Well, then what are facts? Facts are relevant pieces of information that assist the investigator in defining and explaining what happened. Facts provide a degree of certainty, not absolute certainty, that are relevant to the allegation and help the investigator reach a conclusion or a finding. And the finding is based on the collection of these facts. In order to determine what facts are relevant, the investigator must determine the purpose of the investigation, which will in turn shape the investigatory question. And we'll talk about this on the next slide, the investigatory question, that is. In attempting to answer the investigatory question, the investigator will collect evidence. Relevant facts are compiled into 4 forms and then 2 types of evidence. The 4 forms are testimonial, documentary, physical, and demonstrative. The 2 types of evidence are either direct or circumstantial. We'll break these down further in the presentation. So the investigatory question guides the investigation as it identifies its purpose, the relevant facts to be gathered, and the question helps the investigator remain focused. Key components of the question are gathered from the initial reports about the allegation that the investigator receives. The investigatory question should be a description of the intersection of time and space. The investigator then focuses on that intersection of time and space and identifying facts of the allegation. For the purpose of working through an investigation, let's use the details of this reported allegation to form our investigatory question and proceed through the investigative process. And just note that this is a sample allegation. Oh, what was reported? Carlton reported that Annie and Bob had sex on Thursday January 23rd, 2021. Annie and Bob allegedly had sex while at day support around lunchtime. It was noted or reported by Carlton that Bob has a bruise on his left arm. And reportedly, both employees were, quote, preoccupied. One was playing games on a phone while the other was doing some cleaning up. And lastly, the day support building has one large open area and two separate restrooms, one for males, one for females, and then a staff office. Well, how should the investigatory question be constructed? Remember, the investigatory question should seek evidence associated with the time and space of the allegation. You want to avoid developing a question that prohibits you from gathering information. So you want your question to be open-ended instead of closed-ended. So an example of a closed-ended question would be, was employee one on the phone? That question just allows for a yes or no. It doesn't give us the opportunity to gather more information from the witness or from our investigation. An example of an open-ended question would be, what was employee one doing? So that question rather allows for more exploring of the facts. And one thing to note, those two examples are not the actual investigatory question. They're just simple examples of the elements as we were discussing, closed versus open-ended. The actual time of the alleged incident is not known, but it is based on our sample allegation. But it is okay to approximate, given that it was reported to have happened, quote, around lunchtime. The date, however, is known. So what we know is that if we were trying to formulate a part of our question, it would be, what was employee one doing around lunchtime on Thursday, January 23rd, 2021? You also want to be clear in the wording of the question, and you want to make sure that terms and words that you're using, that they are operationalized. So for instance, if you were talking about someone's behavior in your question, well, what does behavior mean? Are we talking about what does that behavior look like? Are we talking about an angry behavior, a happy behavior? Another example is if you were to use the term appropriately. So what exactly does appropriately mean? Well, all in all, the point to this is that you want to be clear and you want to make sure that the words that you are using are very concrete. You don't want to have any variance. You don't want someone to have to make an assumption of what it is that you are meaning. You also do not want to assume that there was a violation or that abuse or neglect occurred. So you don't want to form your question with that prejudice documented there. So you wouldn't want to state a question such as this: did employee one's failure to provide appropriate supervision contribute to neglect? Well, we're already making an assumption that employee one did something wrong by talking about their failure. We're also utilizing um, an ambiguous term by saying appropriate supervision. Well, what exactly is appropriate supervision? Lastly, instead of how did individual A cause the bruise on individual B's left arm, it's better to ask, how did individual B's arm become bruised? Again, with that question, it's concrete. You are not making any assumptions as to what happened. You're leaving the question open to allow for some exploring. So now that we've discussed what the investigatory question is and how it should be formed, let's say we can identify the best investigatory question for the allegation we received. And just as a reminder, so you don't have to go back and flip through the slides, here's the information that was reported based on the sample allegation. 1, Carlton reported that Annie and Bob had sex on Thursday, January 23rd, 2021. Annie and Bob allegedly had sex while at day support around lunchtime. Bob reportedly has a bruise on his left arm. Reportedly, both employees were preoccupied. One was playing games on the phone while the other was cleaning. And 5, the day support building has one large open area with 2 separate restrooms, one for males, one for females, and a staff office. So, which of these questions do you think represents the best investigatory question? So, question A is not a suitable investigatory question because it concludes facts. Employees failed to provide supervision. It does not provide reported detail concerning time, and it does not include the space that the allegation was alleged to have occurred. So it doesn't talk about the fact that it was alleged to have occurred in the day support program or the day support building. Question C has some good components. It provides detail for space and time and is open-ended. But it concludes that Annie and Bob actually had sex. This is disputable. Also, is whether the individuals had sex the only issue here, or even the primary issue. This question does not lead the investigation to determine whether neglect non-peer-to-peer occurred. Question B is our best option here. The question is open-ended. It provides detail for space and time. Language is concrete, and the question is not disputable. So let's just do a little bit of a review. So in forming the investigatory question, the question should seek evidence associated with time and space. You want to avoid developing a question that prohibits you from gathering information or exploring what happened. And you want to be open-ended, not closed-ended. If you don't know the exact time or the exact space, it is okay to approximate that information. Don't make anything up, but you can approximate. So in the case of around lunchtime, we can approximate that time. You want to be clear in your wording. You want your words to be concrete. You want them to be operationalized. And you do not want to assume that there was a violation. As mandated in the human rights regulations in 12 VAC 35-115-175, which is the human rights complaint process, the investigation for all abuse and neglect allegations must begin no later than the next business day. We've talked about that previously. It is important to be timely in conducting your investigations to ensure evidence is preserved when and if possible. It would be beneficial for the provider's internal policy and procedure to document roles, to document responsibilities, and an order for the investigation. So the chart here on your screen is an example of different roles and responsibilities. It is not an exhaustive list as it only relates to the very beginning of the investigatory process, which is, of course, being at the scene. Additionally, not all allegations of abuse or neglect will involve injuries. It is important to understand the steps or order of the investigation process as it relates to the allegation and investigation in which you are, in fact, investigating. The investigator should always visit the scene of the allegation to collect any physical evidence that may exist and demonstrative evidence. And we'll talk more about what those two types of evidence mean. Familiarity with the scene will go a long way in helping the investigator be informed, especially as the investigator begins to question witnesses. And the investigator should question witnesses at the earliest opportunity, as witnesses will be able to recollect the events of the incident easier when the event is fresh in their minds. And witnesses should be kept separated as much as possible to prevent discussion of the event. When interviewing these witnesses, it is best to interview the person making the report first, then the victim, next, any eyewitnesses, and lastly, the alleged perpetrator. You want to make sure that all mandated reporter requirements are followed. So in other words, reporting to APS or CPS, and also law enforcement if there's any suspicion of criminality or any known criminality for that matter. Remember, if the investigator is the subject of the investigation, that person is not allowed to conduct the investigation. The investigation must be impartial. Ask yourself how your internal policies and procedures account for this. It is imperative that investigators are prepared when entering the field. Building a toolkit or a go bag, like they say on some of these TV shows, will prove beneficial as you conduct your investigations. Even consider snacks, because you could be out in the field a very long time and may not be able to go and grab your usual lunch. So think about your health and your wellness as you are in the field conducting these investigations. Your toolkit should also consist of anything that will assist you in performing your job effectively and thoroughly. Again, the information presented here on your screen, it is not an exhaustive list. They're just examples to trigger your thinking. So I mentioned preponderance of the evidence a bit earlier. So preponderance of the evidence is defined as the factual evidence gathered, which demonstrates it is more probable than not that abuse or neglect occurred. If the factual evidence gathered supports a 50.01% likelihood that the allegation happened, then you have preponderance of the evidence. But we'll now finally get into the forms and types of evidence. So what are they? Testimonial evidence is information which is verbally communicated or equivalently given by an individual based on their account of an incident. Documentary evidence is how testimonial evidence is preserved. So, for example, witness statements, policies and procedures, or client records. Physical evidence are those tangible items which are related to the incident, including injuries sustained as a result of any restraint. And demonstrative evidence are pictures, maps, diagrams, which may be retained in the place of physical evidence that may not be able to be preserved. So, like an injury, because of course we know an injury hopefully will heal. So, taking a picture of an injury and an alleged abuse allegation will prove very beneficial. Types of evidence, specifically direct evidence, answers the investigatory question conclusively. On the other hand, circumstantial evidence are any set of relevant facts other than eyewitness testimony. An important note, evidence has a half-life, particularly physical evidence. The environment can cause rapid changes to evidence. So we just need to be careful in our collection of evidence, particularly physical evidence. An example that we always give is, let's say there is a liquid that spilled on the floor that may have contributed to an individual's fall. Well, that liquid can dry if it's not observed in a timely manner, or it can be cleaned up at the scene, especially if the scene is not properly secured. And the cleaning up can be unintentional or intentional. Likewise, the longer it takes to interview a witness, so the longer it takes to collect your testimonial evidence, the more likely it is that the witness may not be able to readily recall events of the incident. Or on the flip side, witnesses may have the opportunity to get together and discuss the event. And why that is not preferred is because it skews the thinking of the witnesses and it decreases witness credibility. Physical evidence is any object or an arrangement of objects, any substance or condition of a person's body which has the potential to describe or explain what occurred during an incident. Remember, it is important to begin the investigation as soon as possible. Per our regulations, the human rights regulations, investigations must begin no later than the next business day after becoming aware of an allegation. It is important that each provider have clear, documented protocols for conducting investigations. Included in the investigation protocol should be procedures for collecting evidence. Most importantly, is to maintain the chain of custody. And that begins at the time the scene is secured. As all evidence is collected, including physical evidence, the evidence should be properly tagged and labeled. You want to make sure that you're documenting on the tag what the evidence is, the date that it was collected, the time, and the place it was collected, and also the name of the investigator collecting the evidence. It would also be beneficial to include a unique identifier for each collected piece of evidence, just for tracking purposes and organization. It may also be beneficial for you to include the CRIS number that's associated with the evidence. The provider's investigation protocol should also note a retention schedule for all evidence and how and where the evidence is to be stored. Specific to injuries, the presence or absence of injuries may help in determining whether the allegation occurred. However, whether there is or is not an injury does not mean that the allegation did or did not occur. It is a piece of the investigative puzzle. Important steps to remember when faced with alleged injuries include observing the alleged injury as soon as possible, even if the alleged victim has already been treated by a medical professional or first aid for that matter. Also, if possible, you want to take pictures of the alleged injury. Also, if the alleged victim was treated at the hospital or urgent care or by their primary care physician, you want to request that alleged victim's complete medical record. And you want to make sure to review the records and ask clarifying questions if needed. Also, in the event that the alleged victim was injured by the alleged perpetrator, you want to check that alleged perpetrator for possible injuries. So, for example, things like bruised knuckles or scratches. Checking that alleged perpetrator can go a long way in you having a fuller picture of what the allegation actually is. And lastly, you want to avoid assessing the injury. We're not there in a medical capacity, so you want to allow the medical professional to give a diagnosis and also a prognosis. Demonstrative evidence is the manner by which physical evidence is preserved. Demonstrative evidence can include things like pictures, maps, or diagrams. Pictures and diagrams may be beneficial as you, the investigator, uh, may need to refer back to the scene throughout the course of the investigation. So, having documented evidence of exactly how the scene looked at the time of the allegation is preservation of the physical evidence. You want to make sure that you follow your organization's internal protocol for conducting investigations, including maintaining the chain of custody. When a witness communicates their memory of the allegation, including their assessment of what happened, the witness is providing to you testimonial evidence. It is an extremely important part of the investigative process to identify all potential witnesses and to interview them. Though there are 5 types of interviews, only 4 are relevant to investigating abuse and neglect allegations, and they include incident interviews, exploratory interviews, background interviews, and follow up interviews. Incident interview involves interviewing those individuals in or around the area of the incident when the incident was alleged to have occurred. It is important to note that the individuals may or may not be eyewitnesses. Also, these interviews are important as they may be able to offer information about what happened prior to or after the alleged incident, and to identify other people involved or around at the time of the alleged incident. The exploratory interview is conducted to determine the time and space that the incident was alleged to have occurred. Remember, time equals when and space equals where. This type of interview involves speaking with individuals who may have been in contact with the alleged victim or in the same location as the alleged victim and is able to offer relevant information. Background interviews are used to gather information not specifically related to the alleged incident. Examples include information such as history of the relationship between the alleged perpetrator and victim, or an individual or an employee. Lastly, a follow-up interview is conducted to ask questions that may have been forgotten initially, or to gain some sense of clarity when there's conflicting testimonial evidence or evidence that is in conflict with other forms of the evidence that has been collected. As with preparing for the overall investigation, the investigator must be prepared to begin conducting interviews. The investigator should consider the following prior to interviewing witnesses. which should be a part of the organization's internal investigation protocol. One, ensure that the witnesses are separated at the scene. As much as possible, if the witnesses are not interviewed at the scene, the witnesses should be kept separated or at minimum informed that there should not be any discussion of the alleged incident until being interviewed. Number two, as we talked about previously, the investigator should visit the scene of the alleged incident to gather firsthand knowledge of the space. Number three, it's advantageous to write an outline of the important topics or areas to be discussed during the investigation, excuse me. These topics or areas should be generated from what is known about the alleged incident. So, for example, the time, the space, and any other information documented on the internal incident report. Do not, I'll repeat, do not write a list of questions, as the investigator should be focused enough on the witness's statement that follow-up or probing questions are asked. So again, we recommend that you do not write your list of questions. If the investigator conducts the interview from a pre-written list of questions, valuable information could be missed. The investigator must remain cognizant of their presentation while conducting the interview. So being mindful of their tone, being mindful of how they're presenting as far as their nonverbals. The interview should be a respectful interaction and not put the witness on guard. That was number four. Number five, to prevent being tongue-tied or at a loss for words, make sure to identify the purpose for the interview. Again, the interview should be a respectful interaction and not cause the witness to feel threatened. And number six, the interview should be conducted in a private, quiet space. You want to make sure to identify an appropriate space prior to conducting the interview. Now that you're prepared for the interview, it's time to interview your witness. In conducting an interview, as we talked about just a bit earlier, the investigator must be cognizant of their demeanor. The witness should feel as comfortable as possible throughout the interview process. Importantly, the goal of the interview is for the witness to provide answers to the investigator's relevant questions based on the witness's recollection of the alleged event. The investigator should not be biased and attempt to get the witness to confirm the investigator's preconceived presumptions of the alleged incident. And this ties directly to your well-written investigatory question that, of course, is leading your investigation. In conducting the interview, the investigator must be able to clearly articulate the purpose of the interview. They must be able to ask relevant questions, and they must accept what the witness communicates to them. The investigator has to be attentive to not only what the witness shares verbally, but also the nonverbal cues that the witness is demonstrating. So does the witness's answer to a question match what their body language is saying? The witness should understand the purpose and be willing to engage with the investigator throughout the interview process. As you prepare for the interview and begin conducting the interview, be mindful to ensure that there is privacy. The interview should be conducted in a space that is free from distractions as much as possible. Make sure that you have allowed for sufficient time to conduct the interview. Schedule more time than what you think may be needed. It's better to end early than keep your witness longer than the witness expected. Remember, the investigation should begin as quickly as possible, but no later than the next business day after receipt of the allegation. In that respect, it is best to keep the witnesses separated so that there is no opportunity to compare what was observed, and distort each of the witnesses' perspective. As you engage with the witness, be mindful of your own demeanor, including your tone, your voice inflections, and your nonverbals. Again, we discussed that previously. You want to be clear, concise, and direct in your verbalizations, making sure to phrase questions open-endedly. Again, you want to explore. Be careful not to ask leading questions, as the goal of the interview is for the witness to state exactly what they remember, not what you, as the investigator, want the witness to verbalize. And actively listen and ask follow-up questions as appropriate. Lastly, an important factor to consider as part of the collection of testimonial evidence is the witness's capacity. Does the witness have capacity? Do they understand why they're there? Do they understand the questions that you are asking them? As previously discussed, documentary evidence is how testimonial evidence is preserved. Documentary evidence is related directly to what we just discussed, that being testimonial evidence. The two types of documentary evidence are witness statements and other documentation typically gathered from your organization. Documents may include medical records, agency protocols and procedures. They could be the individual's ISPs or BTPs, and those are just some examples to name a few. Concerning the witness's statement, several factors have to be considered. One, the investigator should interview the witness first, then have the witness write their statement. Two, do not leave the witness alone as they write their statement. Three, the investigator is not responsible for editing the witness's statement. And number four, should a witness be unable to read or write, the investigator may write the statement as the witness verbalizes their answers to the investigator's questions. The investigator should then ask another individual, preferably another trained investigator, and definitely someone not associated with the current investigation, to read the statement to the witness and get confirmation from the witness that the statement is indeed accurate. The investigator should also make sure of the following related to the witness's statement. One, if the witness's statement is difficult to read, the statement should be typed. Two, the witness needs to sign their statement after reading it for any errors. This validates the statement. If the witness makes any changes or corrections while reading the statement, make sure the witness initials and dates those changes. And finally, the investigator should ensure the witness's statement includes when and where the statement was taken, who took the statement, the name and title of the witness, and the investigator's signature. As stated previously, each provider should have an internal process or protocol for conducting investigation. This includes the written report of findings. Such a protocol will create consistency and decrease the likelihood of subjectivity between investigators. The investigative report is a clear, concise, and organized presentation of the entire investigative process. The full investigative summary should be maintained while a summary of the investigation is documented in CRIS. And FYI, I did mention previously about the Office of Human Rights look behind process, but I just want to reiterate, when the regional managers come out for this retrospective review, they will ask to see the full investigative summary. And not just looking at what has been documented in CRIS. At a minimum, the human rights regulations require the investigative summary to contain whether abuse or neglect occurred, the type of abuse that occurred, and whether the abuse or neglect led to any physical or psychological injury. Consider what is here on your screen when formatting your investigative summary. You want to include an introduction to the investigation and a description of the allegation as you received it. A thorough summary will outline the timeline of the investigation and the processes followed. Be mindful to document your hard work by providing a summary of all of the relevant evidence you collected. And lastly, ensure the summary provides a conclusion of whether abuse and or neglect occurred based on the relevant facts and evidence. This conclusion is the investigator's recommendation to the director, who will ultimately make the final decision whether the complaint is substantiated or unsubstantiated. The investigative report is a professional representation of you as the investigator. Each report should reflect such professionalism. Essential elements of a well-written report include that the report is factual. Remember, facts are pieces of information that can lead to some degree of certainty. You want to make sure that you as the investigator separate fact from fiction. The report must also be accurate, meaning that the facts are specific and detailed. The summary should be objective and that the investigator avoids biased language and judgment. So, for example, words with negative connotations. The summary should also be complete. We know the summary is complete when it includes the who, what, when, where, why, and how of the investigation. A well-written report also includes the actions taken, what is said and what is done. The well-written report is also concise and clear. The language is simple, it's to the point, and it's concrete. And lastly, the report should be mechanically correct, using proper grammar, and it should also be legible. In determining whether an allegation occurred or not based on a preponderance of the evidence, we use the language substantiated or unsubstantiated. An allegation of abuse or neglect should be substantiated when the facts and relevant evidence gathered suggests that it is 50.01% more likely than not that abuse and or neglect occurred. Importantly, the allegation you initially begin to investigate it may be unsubstantiated, but during the course of the investigation, you could uncover a different or additional types of allegations. For example, the initial allegation was physical abuse, but during the investigation, you find that physical abuse did not occur, but verbal abuse did occur. So in this instance, physical abuse would be unsubstantiated and verbal abuse would be substantiated. Again, physical abuse would be unsubstantiated and verbal abuse substantiated. Even though an allegation may be unsubstantiated, consider the need for corrective actions based on systemic needs. Do the internal policies and procedures need to be revised? Do staffing plans need to be addressed? Or should an in-service on a particular topic need to be held? Thank you so much for your time and attention as we discussed and reviewed the investigatory process and those human rights processes relevant to investigating abuse and neglect. Should you have any questions, you may contact me, Carlton Henderson, at carlton.henderson@dbhds.virginia.gov. You may also contact your assigned regional advocate. A copy of the regional map with the relevant contact information can be found on the OHR webpage.